My first question is, what caught your eye with regards to this case to cause you to want to get involved in it?
Well, there are several dimensions. First, it is a free speech case, and that's intrinsically of interest to virtually every lawyer. It certainly is to me. Secondly, it was the context of student speech in schools. And thirdly, I was deeply concerned by one dimension of the case, which was the denial of qualified immunity to the school principal, Deborah Morse, who made this judgment and then executed on that judgment that the banner should come down. And so the probability was, unless the case settled out, that on remand that there would be a trial. And that trial could in fact expose the principal to punitive damages. And I think the educational system, I've always been involved in the educational system, whether as a volunteer or as a teacher in some capacity or other. I think the educational system in our country is under enough pressure, stresses, and strains. And so I'll just go ahead and be frank. I was offended by that dimension of the ruling, and so I felt no small amount of moral outrage that a principal proceeding in good faith, you can agree or disagree with their judgment, could face the possibility of punitive damages. Now, people could very well say, well, that's just not going to happen, it would settle out or whatever, but I just felt it was a very dangerous precedent for the orderly administration of the schools, and just dissuades good, honorable people who love the students, who love the education process, from either entering the profession to begin with or remaining in the profession. And indeed, not long after all this erupted, Deborah Morse said, you know, I've had it. She's no longer the principal of the school. She was involved in special ed at the time of the case being argued in the Supreme Court. And I just thought that was wrong, unfortunate, just ill-served the law, and certainly ill-served the public policies informing our educational system.
Mm-hmm. Judge Starr, there are some people, including Joe Frederick himself, who say that this was not a school-sponsored event and that he had the First Amendment rights to express his point of view, the bong his message that appeared on the banner. What was your point of view on the real purpose of his message?
Well, I took to heart what Mr. Frederick, what Joseph said in his deposition. The case wasn't tried, but in his deposition, when asked that very question, he said it was nonsense. That's not my characterization, it was his, and it was intended to get attention. And so I simply accepted his characterization of it and did not view it as a political statement such as we should legalize marijuana, legalize drug use of another kind, and yet at the same time I viewed just looking at the record, and looking at the photographs, looking at all the circumstances, reviewing the record as I was evaluating the case, I did come very promptly to the view that the principal was simply faithfully enforcing a written school policy that favored student speech. It said we encourage student speech on issues of politics, public policy, and so forth. So it had a very robust pro-free speech policy that was being enforced by the principal, but it created two relevant exceptions. One was a message that could be interpreted as promoting drug use. Another was promoting cigarette or tobacco use. And then there was, of course, concern, as there is in every school, of alcohol use and alcohol abuse. But the real burden, as I saw it, was can a teacher, or a principal in this case, make a judgment, and it's a snap judgment, it's on the scene, things are moving quickly, that particular message could be interpreted as promoting drug use. And bong hits is well known. That has to do with drugs. It does not have to do with theology. It does not have to do with politics. It has to do with particular individual behavior.
You know, when you and I and John Tinker and our friend Howard Bolting did the telephone interview several years ago, I think even John Tinker was surprised that you spoke favorably of the original Tinker decision, didn't you?
Yeah, I think that was John's reaction, and obviously the Tinker decision has come under enormous criticism, but very thoughtful people. And of course, it prompted a dissent at the time by a great friend of the First Amendment, Hugo Black. We see concerns on the part of Justice Alito and Justice Kennedy in their concurring opinion in the Morse v. Frederick case about granting too much discretion to school officials. That's on the one hand. Then you see Justice Thomas in his concurring opinion sort of echoing Justice Black's dissent. Who's in charge anyway of our schools? Is it the schools and Deborah Morse the principal, or is it the students? And it sounds obviously like a rhetorical question, but it's the kind of question that both Justice Black at the time, Justice Thomas more recently asked. But I think, again, that Tinker got it exactly right. There should be a baseline of freedom. And then there really is, and what that ends up doing is putting the burden on the school to justify the departure from the baseline and say, no, you cannot, in fact, engage in that kind of speech. I think that's the right kind of framework, but a lot of people just don't agree with that at all.